Ma'am, they are bringing. They are bringing it.
It is a sir. It is a sir. It is. I make a big sort of ask you to decide which team to go first. Then I can subject. So I for example, if I was like, go to the report, Greater than.
With the solution, I would like to start with the so good afternoon everyone. I'm Govinda Aswa. I will be manager of this institution today. So first of all, I will request all the entities to stop their remotes on the electronic devices and please remain silent in this forum. So I welcome everyone to the underground of the first GCCIL-IBBI National Box CIRP competition. This is a special training of the NCLT consisting of 4 members. So Ms. Muna Malhotra, Ms. Madhurama Kumari, Mr. Malhotra, and Mr. Shobhi Kambi will be guiding this presentation. As per the bench solution, I would request Team 24 to proceed with their submissions. Thank you.
Of 27 February 5. On the same level, after I received the photo, if I'm written consent, same order, then I give my consent. Then I create a process ID, which can be set as an email ID to submit the claims or discuss anything with any formula of communication for on the basis of the corporate. After this, I take over the affairs of the corporate. Once I take over the corporate, I file each form. I submit to me according to the episode that we was published in on August 8, August 2024. In this, they have stated that charter rules I have a company, which I did receive. Then I uploaded the order of the NCLT certified copy. I uploaded the copy with stock exchange, IBBI, check, insolvency provisions. Insolvency provisions for me, I then it's quotations from various distributors for public protections. That can be done from their public purposes. So I just go to how the so and if there is anything that is irregular in the process, I will carry out of that. I have only 8 minutes, so why don't you make the best of that? I will do you're saying that what you want here. Yes, yes. That's not relevant for here, right? So I was informed the competition that we have to go on with. It's a real big issue. If the board wants to go ahead. So after I get some quotations, I published two newspapers, one in English newspaper, one in regional newspaper, stating for invitation of claims from the creditors and also informing them that the moratorium has indicated. After this, I also filed an application before the Honorable NCLT and state that the electricity and water has been cut for my company. I informed them that as it is an essential part of my business, please direct the board of those water and electricity to bring the fact and the status. Also circulate a public announcement with the identified financial creditors, operation creditors, and government authorities. I can book of account that has been submitted to be by the board of directors, which I asked for from them. I think on the critical issues that can be informed me so that I can inform the company. After this, I also write a paper which gives them the moratorium authority will begun. And so this is the claim that is out of the property and final payment with the I also informed Sam, who's an operational creditor in this case, and they have also filed a bankruptcy claim in the Japanese. They did the same with us in the NCLT bench, but the NCLT bench decided to go against it because it had been already been approved for the petitioner. Later on, I also informed Italian as well as GCCIL-IBBI. I speak to them to Italian who wanted to go against section, go on the basis of section 128 and Italian and GCCIL-IBBI got the offer, got the order on their basis on section 14 of the Security Act. But it won't be applicable because the moratorium was already and we find them later. I also ascertain the banks of the cooperative. Then they will have to execute on the basis of the order of the honorable bench and the public announcement that happened. So these things made once they do that, they asked Indian Bank to deposit the initial amount of the CIRP first, so that I can carry forward all the workings of the normal corporate debtors, keep it as an ongoing concern. Later on, I published the ED, which is Enforcement Directorate, and SFIO, Serious Fraud Investigation Office, about the initiation of the CIRP. At the same time, I've also informed the directors of the company who have been suspended that there won't be any immunity that can be sought from my side, as a moratorium just gives immunity to the corporate debtor. Later, I also filed an interim interlocutory application in the Operation and Risk Management case, which is in front of the NCLT bench of Delhi. I informed them that the interlocutory application cannot be gone against the corporate debtor, but they can still go against the directors of the company, as it is given in the Ansel case. Later on, I have meeting the employees of the company, let them know how I'll carry forward the business. I inform them about how proceedings will go ahead and how to keep the company as an ongoing concern, and their salary will be paid the same way as it has been going forward till now. Later on, I also inform the vendors of the company stating that to keep going on with the vendors supplies that they already been giving us, and we will carry forward the payments. Later on, I informed the bankruptcy trustee who has been appointed by the Japanese court. I state to them that we shall take a holistic approach, that we can work together. I inform them how we will go ahead forward, and on the basis of the protocol that has been set, we will set a protocol between us, and we will work on the basis of the entire order that has been given to us in the case of Jet Airways. Later on, I will to all the properties of the corporate data which has been given to me on the basis on the book of accounts and all the data that has been given to me. I check those properties. I look for those properties, I verify those properties if there is any discrepancy, and I file an offense notice that the initiation of the data has been gone forward. Later on the 3rd of March, I file a CIRP form to IBBI, I state to them what all things have been carried forward since the initiation of the process till the public announcement. I also try and start doing the information memorandum. I create an information memorandum which we will later on submit it to the court. IRP, which is me, will acknowledge an email which has been sent to me by the insolvency, which has been sent to me by the IDA. I'll acknowledge the email and let them know that they will be taken as a secured operational creditor with claim amount which will be decided later on by the High Court of Pradesh, and will be deciding the same. The email being acknowledged is on the basis of Greater Noida Industrial Development Authority versus Prabhjit Singh. In this court, Supreme Court ordered and informed that an email can also be acknowledged by the IRP stating that the claim can be approved for the season. Later on, I received the last date of the claim being 7th March, which is 14 days from the date of the initiation of the CIRP. I keep collate and verify all those claims within 7 days time frame, which is on 14th of March. And within 2 days, I submit the proof of claims with NCLT. I also inform them about the constitutional institution of the COC bench. Then I seek for quotations from verified registered valuers, forensic auditors, secretarial auditors, and legal counsels who will be present in front of the COC bench in the first COC meeting and later on. I also disclose my relationship with the financial creditor, if I have any, with the insolvency professional agency. Also, I sent notice to the COC. I send this notice also to the erstwhile directors and also to the operational creditor in this case, because operational creditors USAS has more than 10% of the total claim amount. So but they still won't have any voting rights in the complete process of the COC. Later on, after the meeting has been done of the first COC meeting, I was not selected to move forward as an RP, but within the 5 days time frame which I was not selected and it was going forward to the RP, I send a voting agenda to the voting agency. We conduct the voting session for the first COC. We appoint a registered valuer, which was not more than 47 days from the date of the CIRP initiation, and I also appoint a transaction authority. After this, the RP, which was appointed after me and was built in the proceedings of the CIRP and the company. So I'll take the lead and ask the RP to go forward with the following question.
So first question is regarding this IDA issue. Yeah. So how important is this of the business of the corporate entity? You said it directly.
Yes.
From a claim perspective, but what did you make any payments?
So, like, for the email, CCT that they will be offered and they will be agreed to be as a secured operator. So, they will be given on the basis and the level of percentage on the basis of secured operator. So, that is what I email payment was made to them till then. And at my level.
Did they ask me?
No. Just agreed and then given secured operation creditor. There was no commitment as such given my side. Then we paid on the basis of the previous amount that has been supposed to be given by them going forward. Going forward, during the time, yes, they will be paid.
Sir, something about what is the
Yes. After the decision.
But if you expect him to follow the services without pay.
From the CIRP, that has been imposed by the petition. Yes, you're right.
The next question is when you pick up other companies, seeing any big difference in the company reactions or the SFI done.
Yes, that was a discrepancy, which was sort of there was a discrepancy on MS Pravi's case where entity was not in the pitch, even 1,000 crore over pitch. But it was still under process. We didn't value anything because we asked for the directors of the company to inform us about what is this transfer of amount that is being done. We didn't do anything on the basis of natural justice to hear the side of the directors first, and then we will carry forward the process that can be done.
Thank you so much for the comments. Yes. So, really shows that. Yes. So it's what is the reason that gives silent?
So I was not made aware of the issue, but I also had during the meeting of the first use informed them about the ongoing various CIRP proceedings under me. So I also informed them that a lot Yes, but due to period, the consent form to the Indian.
That and the expression of interest that is to be done within 60 days from the COC. The approval of the COC was taken on the same. The approval of COC was also been taken on the insolvency resolution process, which has been carried by from the date of commencement of the COC. After the meeting, the minutes were submitted, circulated within 48 hours from the conclusion of the meeting, and the voting window was open, and the timeline for voting window was open till 7 days. That is the maximum as per the amendment of IBBI on 15 February 2024. That the voting window should not be open for more than 7 days in the case of voting agenda is being circulated through e-voting. After this, the Form G was published in the two newspapers, one in the in regional language and one in the English language, inviting for the resolution for the prospective resolution applicant. In between, we have conducted the meeting with the employees and the vendors of the corporate debtor, carry out a proper and a clear resolution of the corporate debtor, and to keep the corporate debtor as a going concern. Because keeping the corporate debtor as a going concern will fetch more value and will create a greater plan and greater resolution effectiveness. And we ensure that the employees, that in every stakeholder, that the proper payment will be made as the company is to good business, and we are getting a good approvals from the business of the corporate debtor. As the corporate debtor itself is a brand and which have a hotel all over the India. The third COC notice was issued to the COC member, in which the update was given about the Form G, and that we have received an expression of interest from two provisional resolution, prospective resolution applicant, and it was appraised to the COC member, and undertaking for the same was taken from the COC member, and we have and we appraised the member and the prospective resolution that
plans? See,
We received only 2 AOIs, ma'am, as of now. We are in the current the fourth meeting. Like fifth meeting, we are before the fifth meeting, we considered one resolution plan which was received by us. We filed an application before the Honorable NCLT and the same was discussed in the COC meeting. The time limit is for 135 days from the insolvency commencement date to filing of transaction audit report. And the same was application was filed and the same was duly informed to the COC member that the application is pending before the plan was open in 6 COC meeting and the RA was invited. A plan compliance checklist was made by the resolution professional and stating whatever the compliance as per regulation, as per section 30 and regulation 36 was duly complied in the plan and the interest of stakeholders were duly recognized. I hereby hand over the resolution application, given detail about the resolution plan which will be submitted in the 6th. So the voting percentage was 75% was held by the Union Bank, which was the lead bank. The next percentage was 15% by ICICI Bank, 15% by Bank of India, 1% by ICICI Bank, 1% by CT Micro, CT Finance Micro, 15% by BOI, 1% by ICICI Bank, and 8% by SBI. And there was
actually take the financial worth of
so we made an evaluation matrix and we in this UC meeting we decided eligibility criteria that according to the balance sheet which we had for the last year, what should be the net worth and what should be the turnover and what should be the size of the resolution applicant take over the corporate debtor as in because the corporate debtor itself is a huge entity which is having an operation all over the Indiana and also in South. to credit a certain criteria which was met by the resolution applicant and which was informed to the suit.
Yes. Various other businesses that they have. So, exclusion is eight fatalities. So, all businesses.
As the record limited was having a strong, even though they were new entry in the wealth business, they have multiple branches or multiple wells across the country as a subject. And resolution applicant is someone who having a prior experience as well, in turnarounding the company, distress company, which they have been stated in the resolution plan as well, that they have successfully turned around the company while, and the same plan was approved on the bench. So we considered even that aspect as that they are capable and that strengthen enough turn around the so profitable.
No 29 issues.
Issue we take the intelligence by professionals and we got take that as well and the same was submitted in 6 years.
No secondary sales.
No. The transaction audit was carried out. The forensic audit was only like or two, and SFI has already declared that the transaction is the relevance of the report as well.
One application. Sure. Since you mentioned the books, or this by
Yes, as per our CIRP, we have also filed the same set of intelligence project. Yes, the bachelor's trustee will be and be the representative of the group. He being the representative of Japan, so he will be agreed for his name. But the protocol was
yes, this is but we get it.
yes. There was no.
The second question is what happened to the proceedings in the bank? Or whatever steps were taken? What is the way for those proceedings?
The proceeding, even for them, the whatever the creditors were there, the creditors were told that they should file the claim before the RP here in Indiana. So there can be a holistic CIRP process.
And all of them, right?
As of now, we didn't receive any claim from them. Only the Kipus as the biggest operational creditor has filed that claim.
So, in your experience, what is the how are the events of those creditors with their proceedings will continue?
So we have created the plan itself may create a provision that if any claim within the 60 days from the date of approval from the plan by honorable NCT, if any creditor may file a claim, even though we consider the same and the same shall be paid out by the resolution applicant. And after the 60 days, the plan, all the claims and the liability will stay.
You said that witness application. All right, it's 12. What is the creation of the plan as you get it?
If any order has been passed in this case, the benefit will be given to the corporate debtor and it will utilize for the further course of business for the corporate debtor.
So the creditors are not.
Even if there is any amount which is left, the creditor shall be treated as per the waterfall mechanism by the resolution.
So first right is of the
Corporate debtor.
the resolution.
Not the resolution applicant, but the CD in itself.
Yeah, but this applicant will become the CD. Take over the CD.
Yes.
That does not happen.
But the resolution applicant will not utilize that amount for its own business, like for the other corporate entities of the resolution applicant. It will be specifically for the corporate debtor itself. The secured.
So is the lenders get it or not? Is it passed on to the lenders?
No, it will not.
And is there a provision?
The
they actually first the plan and then
Yes, yes, yes.
and third has the
Yes, the performance guarantee will be there, which will be applicable for a 1 year time period.
what is it?
What is the amount? It will be 10% of the recognition plan.
And the
Yes, it was submitted along with the 20 academic and plans.
was
It should be the RP because the RP present the plan before the bench. As per the mood preparation, yeah, present to the RP. Otherwise, that is the present the plan.
Yes. Thank you, Mahesh, for giving me an opportunity to present the resolution plan. I will present the important aspects of it. I would first like to express my gratitude towards the resolution professional as well, continuing the business of the operator and being concerned for a period of time under CIRP proceeding. To start with, I'll give a brief about the resolution applicant. This resolution applicant is Skyline Properties Limited, which is a part of the Skyline Group, which is driven by the promoters of the hospitality industry. They have veterans and experts on the board of having experience in turning around the distressed property. To start with, the big company has a lot of premium hotels, tier 1, tier 2 cities of Indiana, as well as a loyal customer base in European market, along with properties in the European market as well. Moving to the internal structure, that is, the entity has two wholly owned subsidiaries, which is one is Skyline Catering Services Limited and Skyline Services Private Limited, which is involved in the business of catering for the hotel chains of Skyline Properties as well as other hotel chains. And the second one, which is involved in the facility management of these hotels, thereby enabling a cost-effective and a uniform best-in-class service to the customers, thereby ensuring higher retention and repeat rate for our customers for Skyline Properties as a whole. I would like to highlight that the applicant has been able to successfully turn around a company which is Inter Limited, which was again was a corporate debtor and resolved through the proceedings, and we took over the charge. We turned it into a successful brand. And I would like to state that or any of our related parties have not defaulted on the implementation plan. Further, in this bench, we would request to take over the operations of this corporate data as well, which has key operations in Indiana as well as the emerging markets of tourism markets of Southeast Asian countries, where we will be able to cross-utilize or the loyal customers can use these properties and we can flourish the business here as well. Going forward, I would like to go on to the important provisions of the payout plan. As per the resolution plan that has been submitted, as provisions of section 30. First of all, we have given an undertaking that we are not barred by section 29(8). Secondly, as per section 30, subsection 2A, we will first be treating the CIRP cost. In this case, the CIRP cost we have estimated is 150 crore. In case of any surplus or deficit, this amount would be passed on to the financial creditors and would be paid out in the proportion of their debts. One important provision that I would like to highlight is regulation 31A, whereby 0.25% of the realizable would be paid as a regulatory fees to IBBI if the realizable value is greater than liquidation cost. We have considered the same in the CIRP cost. Further, going forward, there is a claim of EPFO, which is considered as a secured claim. Secondly, as per the judgment of there are two judgments. One is of the Rainbow Papers, and the second is of Assam EPFO inclined judgment, which state that this EPFO claims being a kind of a social security net. Rainbow Tourism Finance, Tourism Finance Corporation of India Limited versus Rainbow Papers, Civil Appeal 116 of 2000. ETF graduate, sir, it actually stated that the claims that are due, the funds actually would not be considered as a part of a liquidation asset. And it was based on the logic of it won't be a part of liquidation asset and therefore it should be outside the preview. So drawing logics from that, and there's also another judgment of Assam. Yes, sir. The fresh commercial.
So what you're saying is that you are going to undertake that.
Yes, in full and in private. Secondly, I would like to also highlight the treatment of the employees here. We will first make an assessment of how and to what extent the employees would be needed in the existing operation, since the operation would be kind of revolved based on the business practice of the resolution applicant. In this case, what we will do is we will make an assessment. Any excess employees would not be terminated, but would be considered and moved as an employee of our subsidiary companies, which would be again part of the servicing of the properties of the corporate debtor. Further, I would like to highlight that there's a claim of IDA, which is considered as a secured creditor in this case, and we would be treating it at par, and we will make the payment at 15%, which is kind of similar percentage at which we will be paying financial creditors as well. Going forward, the other operational creditors would be paid at 1% of their dues, which we understand is higher than the liquidation cost as per the provisions that has been provided. Going forward, we have made a significant provision that the EBITDA surplus for the first 60 days of the implementation plan would be distributed among the financial creditors, thereby giving them an opportunity to get a higher claim for the first 60 days, because 60 days is the period where we will implement the plan, and during this period, the RP will be on the board of the corporate debtor, and at the discretion of RP, decide to appoint a monitoring committee and would supervise and implement the program. Going forward, sir, I would like to highlight that the financial creditors would be paid in 3 tranches. However, the first payment within priority would be to the dissenting financial creditors. That is in the basis the approval by the COC that dissenting financial creditors, they will be paid in priority. Going forward, sir, as per the implementation, as per the sources, what we have tried to put together, the payout is around 1451 crores, and we will be infusing 150 crores as a working capital for ensuring the working of the corporate data as a going concern and flourishing it further. Further to state that we will also realize the non-core investments which are appearing in the books of account. We will realize it, and on the whole of the RA would be in 3 parts. The first 2 would be in terms of equity infusion over a period of 15 days and 30 days after the approval, and the third one would be a debt infusion for the security of RA, but it would be compulsory convertible debentures having a 9% period, and it would be compulsory convertible after 2 years. So this acts as a security for RA as well. So I would like to highlight an important fact that financial creditors are open to proceed against any personal guarantee that has been given. However, we will also highlight that CT Microfinance, which is a related party, we will not be making any payment to them. Any amount which is receivable by the corporate debtor, we will continue to receive it. Those receivable would not be extinguished and would be used solely for the benefit of the corporate debtor. Whereas we ask about the avoidance of transaction, in case we are able to when or successfully recover that amount, it would be used for the further construction of few WIP assets which have been shown in the balance sheet of the corporate debtor. We will be making it turning it around quickly so as to make it a complete property and then having a higher occupancy rate. So further, I would also like to state that any claims which are unascertained or have not been filed would stand extinguished and paid as full and final. No payment would be done apart from the payout plan that has been submitted. Moving forward,
Just touch upon the credit. What is the outstanding claim and now?
so the total outstanding payment was claims for around 36,676 crores, out of which we are paying 1% to the operational creditor. We are paying at the rate of 15% to the financial creditors as well as the secured operational creditors. So
Total payout by you 6,300 is 1,301.
yes, sir.
And the liquidation value is only 900.
900.
We have one, we have a 11 because they paying 200 crore more. Then, okay.
Yes, sir. So that is the value maximization that we think we will be able to generate. And that's the reason we will be infusing the working capital as well, and therefore the total infusion would be around 1,600 crores. Out of which I think 150 or 100 and some crores will be able to realize basis the fair valuation of the non-core investments. So going,
Existing shareholder continue boosted.
yes, sir, I was coming to that. The post structure of the CD would be that we have made an application in the release that we will be delisting the shares of the corporate debtor. It would turn into a wholly owned subsidiary of our resolution applicant. It would become a wholly owned subsidiary of Silent Properties Limited, and as a support, the wholly owned subsidiaries would be functioning for the facility management and the catering services for this companies. So we have sought as a release concession within this resolution plan from the bench. So going forward, we will then use into the capital along with the debt as per the timelines. We have decided that at the start of 15 days, we will be clearing all the CIRP costs.
Your side, this is your question.
Yes.
The law thing never said to us effectively. If it shows this time where does it say that the avoidance of conditions? See, silent.
So it's note number 3. It says that the note number 3 on page number 5. Yes. So the last point, any sum received by the resolution profession or the CD pursuant to any avoidance application, page number 5, the third paragraph. The last line, any sum received by the resolution professional or CD pursuant to any avoidance application, whether prior the NCA period or after, shall solely be for the benefit of the saver.
And the other one was how it will the things of prejudice Japan because the artist and you get a
Yes, sir. So we will be paying 1% since this. Sir, you can see that on page number 3 in the payout plan. The fourth line deals with the operation filters that others not being workmen, the EPFO claim and category claim. We are paying 1% of the dues for telephone grant tax authority entirely.
no, but that is the other thing.
So they have not filed the claim. If before the approval of the bench, if they file, we will be paying them out at 1%. Otherwise, as per the note number 2 that we have mentioned, any other claims, whether a certain, uncertain, is extinguished and settled and deemed to be settled in full. So, but as per the protocol, it basis the protocol that was being agreed, the payout would be done basis the CIRP proceeding to India, which is the center of main interest in this particular case.
Yes. So the first one, in your piece, with the operation that is pending, how do you propose to discuss that?
Sir, there are 2 points. One is we have added that any criminal liability against the corporate debtor shall stand extinguished or would not be proceeded with as per section 32A of the code. That's the point where we have sought relief and concession from the bench. And there are other important relief and concession with regards to tax matters.
Something to because the question is pending. What happens to that?
So that would discontinue with regards to the corporate debt. The powers of the tribunal can be exercised as against the directors of the erstwhile directors of the corporate debt. The assets. There are a few assets in Japan which we have taken charge of. I mean, the RP have taken charge of, and the Now, we have essentially as per the protocol that has been agreed, and in the protocol we had agreed that whatever would be the proceeding that could be as per the Indian law or Indian law. Should have had. In the favor of the corporate debtor. So that to the corporate data, it would be solely to the benefit of the corporate data as per the note 3 that I referred to. We will utilize it for the benefit of corporate data, for example, infusing it into the capital WIP that is still ongoing. So we can accelerate construction and completion of the property that we have. Should I continue?
Yes, the page 7 is indicating jurisdiction grant this.
This is specifically with regards to the payment of interest late fees, because as per the EPA code, even in the judgment, which I referred to, it was stated that the dues that are that the claims that are due to the employees should be settled in full. However, we can request the bench to provide us relief in terms of the interest and the late fees for payment to the employees. Those reliefs we are seeking.
Loss by we have says that 5 or 7. Yes, granted.
So one is in the judgment of SR Steel, where these relief for continuing the licenses certificates have been granted. Sorry, I'm not aware of the other specifically, but SR Steel, there have been reliefs and concessions. Should I continue? Thank you.
Yes, yes. Definitely. This is the face.
Good afternoon, Your Lordship and Ladyship. This is your interim resolution professional, Neha Varma. With me are the resolution professionals, Rishabh Mehta, and the resolution applicant for financial micro, Parisha Jha. The IRB should collectively refer to you as the bench. With this, I would like to give you a time division between us today. The IRB will be speaking for about 10 minutes. The resolution professional will be speaking for 18 minutes. And the remaining time has been set aside the discussion of the details of the resolution plan. Before beginning our submissions today, it is pertinent to highlight that few parameters with which the dossier and resolution plan were prepared. As per the instructions of the competition, we have restricted ourselves from introducing new funds or including funds for the settlement of any debt. That which will be found on page 1, subsection block 3 of the instruction. At the current juncture, we find ourselves in front of the NCLT bench, seeking an approval of the bench for the unanimously passed resolution plan by the COC in the previous book. With this, I will give you a brief background on the corporate debt. The corporate debt of a public company was based in Chandni Chowk, Haryana. They had heavily invested in the hospitality sector before the lockdown, And as you know, the COVID-19 pandemic, they suffered a major setback, and the investment did not give out the expected results, which is why we stand here at this juncture. The current protection expired by the Bank of India under Section 7 of the NBC, and the moratorium period was initiated on 22nd February 2024. Apparently, a Japanese company had also filed bankruptcy proceedings against the company in Japan. Further, there is also been an investigation by the SFIO for negligent cycling of funds against the corporate debtor. Lastly, it is also essential to note that the water and electricity supply would also start rendering it impossible for the corporate debtor to be going concern. In the light of the background, I, the IRP, Commission of the Bench, would like to take you through the development from the initiation of the moratorium to the first review. Bench, if you can come to page 3 of the document, you will find dashed a procedural time. The IRP was appointed on the Insolvency commencement date by the NCLT on 22nd February 2024 under Section 16, subsection 1 of the Code. This was after I was named as the proposed resolution professional proposed to act as the IRP under Section 7, subsection 3B of the Code. This appointment proved that there has been no disciplinary proceedings against the IRP. As part of my disciplinary duties, I undertook the preparation checklist on the very first day. After obtaining the copy of the NCLT, the IRP was premises of the corporate debtor, the registered team, to the office of the DC, Chandni Chowk, or Delhi. The management was contacted, and the directors, management team were informed of the appointment of the IRP. The chief employee, the corporate debtor were informed about the suspension of the power, vesting of powers into the IRP. The physical verification of cash and photographs were taken as documentary evidence. An order was to be placed and safeguarded in 1 to 3 was also made. The password of the computer system's website, everything was taken, and all the data was backed onto the computer systems. A public announcement was made within the first 3 days of the appointment of the IRP, that is on 25th February 2024. It was also published in the register of the IRP, that was in Chandni Chowk. A copy of the announcement also published on the website of corporate debtor and IBBI. A copy of the announcement was also placed at the outdoor side of the corporate debtor. An assessment of the potential risk of the business as going concern was also conducted, such as pending issue of the corporate debtor, their finances, their current finances, and cash availability. The information of the corporate debtor was collected. Their financial assets were noted, the cycle of the operations that they run, about their information about their employees, their recent finances, and their recent media coverage was noted. Based on an assessment and discussions, the size and complexity of the operation and independent research of communication plan is prepared. The value names were changed according to Section 17(1)(3). The details of the financial institutions that were maintaining accounts of the corporate debtor were obtained, and the signature of the bodies into the IRP. A meeting with the partners, the accountants, professionals of the corporate debtor were present in the meeting. Directors, senior management, and team were asked to come up and were required reports. Assessment of any threat to the assets of stock of the corporate debtor were also made. A relationship was established with the staff by answering their questions and taking a report on time. In terms of manpower and resource management, the following were assessed. The organized structure of the corporate debtor was assessed, the relationship with the management was assessed, and the kind of support expected from the executive management was also assessed. The key officers were identified, such as the compliance officer, the company secretary, and in-house counsels. Various legal proceedings pending against corporate debtor were assessed, and the relevant tribunals were notified by the IRP. An effective crisis response plan was set up, and a core crisis committee was also set up. But timeline prepared under Regulations 48, under Section 41, the NCLT made an announcement at the commencement of the CIRP process, and a moratorium was declared, and claims were entitled. All the three collected and three names were verified, which Union Bank of India, State Bank of India, and Bank of India. These three names were admitted, but two of the financial were not admitted. You five were not admitted due to this defense. A committee of creditors was constituted, and all financial creditors such as the Union Bank of India, SBI, Bank of India, and Axis Bank were admitted. The agenda of the first meeting of the COC was the appointment of the president. The second agenda was to decide the remuneration of the IR. Lastly, the COC had to decide whether to resolve the matter or whether to dictate to resolve the insolvency or liquidate. When CIRP had to inform the COC had gone ahead to resolve the matter, and Bishop had been appointed as the resolution professional who, under Section 23, has conducted the CIRP process.
So, what actions have been taken against ST including listed company?
So the listed company.
What actions have been taken?
We send them a notice, and so trading was suspended, and the shareholders were allowed. The trading was suspended, and the shareholders were not allowed. So the argument is ethical.
Why would you start with this?
Oh.
Public announcement. So Oman was the duty of the IRP to make a public announcement. And the public announcement was made within the first 3 days of the appointment, which was on 25th February. A public announcement was made within the first 3 days.
What agenda was
The first meeting agenda of the COC was to appoint a professional, whereas the IRP, but the second, but which is there was an emergency, family emergency, which is why the IRP did not continue as a resolution professional, and it was
that's
Addressing your first, when you talk about the treatment of shares in the listing companies, firstly, since the company noted a successful decision to go on to CIRP process, the public trading shares was continued, while the public shares were rendered to the regulator. But the public listing shares were trading not suspended at that during the moratorium period, and that went on for the possible future. But again, if trading can be suspended if the company can go under liquidation period. And further, these period of shareholders in the resolution plan, they have done it, they will receive 25% of the holdings they have in that company if the plan is successfully approved by the adjudicating authority today. So that's the trading for the listing of the share.
So, what is this comprehensive estimate of CIR? So, any findings are the relevance of the listing.
Since filing the process has commenced with your due to the admission of the petition of the Union Bank of India. And first, SEBI was notified of the same, and shareholders have also been duly notified about the process.
Second question again is for the IRP. So, this is access and
Addressing your lordships and ladyships, collectively seeking your permission to address as a bench. When you talk about the special bench as successfully appointed as a resolution professional of the company, it is my primary and foremost duty to maintain transparency and to have fair valuers being appointed to this company valuation. In order to have appointing two fair valuers, while also giving contingency toward value
on standby in case there is a difference between the two fair values amount, if amounting to more than 25%, the amount that they. So the third fair value was on the standby as well. Moving further, the second order of business is the commission of an information memorandum to the committee of creditors. Now, what would such an information memorandum contain? Our primary duty is to make all the creditors aware about the legal issues surrounding the company or the corporate data at that time. Secondly, also making them aware about the financial position of that company, what are the current assets, what are the current liabilities of the company, and giving them a holistic view of where the company stands here today. Now, coming to what the legal issues are, if your lordships and leaderships could turn to page 5 of our notes here. On page 5, the bench will see 5 issues that we enlightened the committee of creditors upon in the subsequent meetings that we undertook. The first and the foremost issue being of that our limitation period was extended because of the COVID pandemic lockdown. So, because of the pandemic, government had notified regulation 40B, which allowed for an extension of the limitation period, which allowed all the creditors, if their claims were being exhausted during the limitation period, file such claims after the COVID pandemic was over and file for those claims as well. So we have taken into account of that as well and informed the creditors and given a public notice as well to that. Secondly, when you talk about the cross-border insolvency issue that is very highlighted on the factual metrics of Kiku SaaS company in Japan, this particular incident strikes resemblance to the Jet Airways case, wherein Netherlands court attached the foreign assets of Jet Airways in that particular proceedings. But eventually, as we know, there was a successful joint cooperation committee that was established, taking precedence from there. Also being aware that Section 235 and 234 of the Indian IBC have not been notified yet, so we can't take advantage of that in India at the current date. Also, relying on such a precedent, we duly approached the Japanese resolution professionals, seeking his permission and subsequent approval that together through a joint cooperative effort, we can come to a successful resolution of the same assets instead of stressing those foreign assets further. Now, what happened, addressing your concerns about what happens to the foreign proceedings in Japan, we understand that as the resolution professional is an officer of the court of health, his mission acts as a binding authority for Indian authorities to take an action. And hence, after receiving their positive affirmation from their end, only after that, the committee of creditors has approved such a joint cooperation effort between Indiana and Japan. And their proceedings are at the current moment as we discussed this plan today. And that is subjected to if the resolution plan is approved, these proceedings will be withdrawn and will come to a standstill over there. Now, coming to the third legal issue that this entire corporate debtor was facing about the claim of 49 crores of IDA. IDA had informed through a simple notification while having IDA High Court proceedings going on about a claim of 49 crore rupees. We have successfully admitted such a claim and we have made provision for the claim as well, understanding that this could be a potential claim and having a contingency would not harm the creditors over here. In fact, would be putting us in a better position. And hence we have taken this 49 crores also into an account for. Now coming to the third and primary issue, that is of SFIO and its interim report. Now, as already very protected aspect of jurisprudence in criminal responsibility, the previous directors can be held accountable for their past criminal actions. If such a siphoning of funds is allegedly proven by the government or by the state in the proceedings, then these past directors of the companies can be held liable in a parallel proceedings. Now, coming to the question of immunity, immunity can be extended to the new directors appointed after the moratorium is fixed, but not for the previous directors which have taken such actions of such liabilities which are accounted to them. And first, taking reference from IRNF's case, or also taking the reference from recently where Mr. Uday Kotak was given immunity because he was appointed as a new corporate director in one of its CIRP proceedings, and hence we understand that new directors can be given immunity, but not the past directors. Lastly, also addressing the issue of essential services. Now, in our factual matrix, water and electricity being very essential for a business to run have been disconnected. As a addition to that, what we are proposing is we will clear the past dues in a manner is providing the resolution plan, but also we'll be making monthly payments during the CIRP process to ensure such an essential services are continued. How are we coming to such a conclusion? We are relying on the Uttar Pradesh Power Corporation case limited, where it was successfully held that essential services cannot be completely disconnected because of default of payment. During the ongoing CIRP process, if monthly payments are made, such essential services can be continued. But if, however, if the monthly payments are not made, only after the notice of 30 days can such connections be disconnected. It is our solution that we will be providing the monthly payment while also making provisions to pay the past dues as well. This brings us to an end with the legal issues. Now, talking about the financial position of this company and how they were informed in the information memorandum, you can see on the last two sheets of the factual matrix about the company's position in terms of current assets, current liability, and P&L, which was given to the given to the committee of creditors as well for their information. Now, coming back to the procedure procedural times as well. Following regulation 26A, we rolled out an EOI for taking all of the prospective resolution applicants to submit their resolution plan. It is important to highlight the fact that although there were many financial creditors in our factual matrix, but following regulation 29A, the resolution profession had to eliminate all of the banks because they become ineligible under regulation 29A. Subsequently, also City Microfinance being a related party, that party was also not submitting a resolution plan. The only eligible creditor that was left to submit a plan was the resolution applicant in our case, being the microfinance limited. So, after successfully receiving such a plan, it is the duty of the resolution professional to check prima facie that it is legally compliant with an evaluation matrix, which it has successfully done. Now, after going through the resolution plan and going through the evaluation matrix as well, the plan is legally compliant with, and the compliance certificate in the form H is with you on the diet itself. So, when you go through the form H, you see a series of checkboxes that are there with resolution professionals to see if it's complied with or not. So, I sort of follow enough gesture that to make the entire proceedings convenient, we have attached page numbers as well, where on the resolution plan can you see the compliance on. So, hence, if the bench wants to take a minute to see the compliance, then we're happy to allow the bench to see the entire compliance. Form H is given to you, a separate PDF will be given. Yes. Yes, I got you. First, actually over there are two reasons for that. For the same, fair value and the liquidation value have been given to us separately, not in the factual matrix. So we did not even liberty to assume those figures. But while preparing the resolution plan, we have kept a ballpark idea through the past aspects of such a hospitality industry for the fair value, and hence we have arrived at those figures. So it's an assumption that we have undertaken, but not included in the plan. If your losses and leaderships to the satisfaction, we can give a summarization of the proceedings. Addressing your concerns in twofold. Firstly, about the fair assumptions and the fair values report. The resolution applicant will shed more light on how we have come to those values that are prescribed. We did file those. Those reports will be made available after the proceedings.
doesn't say what transpired, necessarily disclose what happened. That's inside. It's all that it is that what I could see. We so this is all the
We'll definitely take a look into that with your permission. Also talking about how moving further about the avoidance transactions issue that you flagged off. When you see about the checklist that we have, definitely seen if there are avoidance transactions or not. Although that is not included in the resolution plan per se, because it was exceeding the age limit because of the structure of the mob competition, of the mob competitions, and hence that is not included in the resolution plan. Moving forward, when you talk about checking for any fraudulent transactions or alarming of the, informing of the committee of creditors about such fraudulent transaction, there was one fraudulent transaction that we came across, which is also being currently investigated by the SFIO. That is a Fragni Limited, about 1,200 crores transactions, which is being allegedly which has been allegedly of stifling of funds, which is already notified to the committee of creditors and also been told about to the court itself today. And thus, apart from those, we could not identify any of such transactions, and those have not been notified to the court because of that. Moving further,
that it was not a company that is even who is happening on the bargaining exists, when it exists or the finding of fact. So it can what is separate. You are just format scale what's that
yes, avoidance application was filed to further investigate what is the actual factual position of that company. Moving further, if there are no further questions from the bench, committee of creditors successfully approved the entire plan. The details of the plan will be highlighted by Ms. Aisha Chapa, the resolution applicant.
Can I seek the permission of the bench to provide it for? May I seek the permission of the bench to provide an overview of the resolution plan that is proposed by the resolution applicant? So the resolution plan is divided into 6 chapters. Chapter 1 talks about the details of the corporate debtor, the resolution applicants, the RP, the IRP, as well as the overview of the project. The details of the corporate debtor, the RP and IRP have already been explained by the IRP and IRP themselves. Moving to the overview of the project, the CIRP process was initiated on 22nd February 2024, after which the moratorium was imposed, and the IRP was appointed on 22nd February 2024. The RP was then appointed on 26th March 2024. Page number talks about the details of eligibility of the resolution applicant. The resolution applicant is microfinance, a financial creditor of the corporate debtor itself. The applicant has a net worth of 10,000 rupees and has negligible debt to its name. It now wishes to take over the business of the corporate debtor and has already taken over the businesses of 3 corporate debtors in the past, for which it had already appointed the management personnel, legal and administrative staff that is equipped to continue the business of the corporate debtor. It is also eligible under Section 29A of the IBC, as well as the RFRP that is issued by the RP. Page number 3 talks about the current status of the corporate debtor that has already been explained by the IRP and RP. Moving to chapter 2. Chapter 2 contains the compliance mechanism that was undertaken under the resolution plan. Chapter 3 talks about the summary proposal. and details of the financial creditors, as well as the operational creditors, and the dues that were claimed and admitted to them. Table 3.1 mentions the CIRP costs. CIRP costs essentially contain the fees of the IRP as well as the RP, and the costs that would be and the incidental expenses that would be undertaken during the moratorium. So the amount that we proposed under that is 40 lakh rupees. Moving to salient features, which is table 3.2. Secured financial creditors. There were creditors not having a right to vote under subsection 2 of section 21. CD finance is a related party, therefore not having any right to participate in the voting or being present. It does not have the right to represent the vote in the meeting of the committee of creditors. Therefore, an amount of 15 crores was claimed by them, but it was not admitted by the RP. There were no unsecured financial creditors. Moving to the operational creditors, there is no related party of the operational creditor. The government dues that are mentioned as 1 crore 60 lakh rupees include the EPF amount that is 1 crore 50 rupees, 1 crore 50 lakh rupees, which will be fully paid by the resolution applicant. It also includes the claims by a government sector telephone service provider of 10 lakh rupees, out of which only 60,000 rupees will be paid to them. According to the factual matrix, there are no dues to the workmen and employees. The other operational creditors include a bill of the food suppliers, the rent amount, as well as a private sector telephone service provider. Statutory dues amounting to 90 lakh will be paid fully, since the security interest is attached to the same. Page number 6 talks about the statement on interest of all these stakeholders. Although the liquidation value due to the operational creditors is not known to the resolution applicant, and the resolution applicant expects the same to be nil, considering the amount of the secured financial creditors, the resolution applicant still proposes to pay to the operational creditors of 3% of the amounts that were claimed by them. Page 7 talks about the distribution of financial outlay of the operational creditors. The telephone department, the government telephone department would be paid 50,000 rupees, which is 10% of the amount that was claimed and admitted. Moving to the telephone department of the private service regulator, about 8% is paid to them. To the food suppliers, 4% is paid. To the 3% is paid. Moving to the treatment of the related party, the related party CT Microfinance is a connected party, it's a connected person under section 29A. Then we can disqualify from the resolution plan and having the right to vote in the meeting of the committee of creditors. It is reasonable to allege that it's the insiders who are responsible for the collapse of the company, and therefore not be allowed to put up a resolution plan. With regards to the treatment of the international operational creditor, a protocol has to be proposed, taking the case of Jet Airways as a precedent. Chapter details the management of the affairs of the corporate sector. To monitor the resolution plan, a monitoring committee will be set up. Only the nominees of the financial creditors will be appointed in the monitoring committee. The monitoring committee shall further appoint ex-restructuring services who are existing professional advisors to the resolution professional. They would be appointed as monitoring agencies the same monthly remuneration as is being currently paid during CIRP. The monitoring committee shall cease to have any powers at the date that the upfront payment is made to the operational creditors. Chapter 5 details the implementation of the resolution plan. The implementation is planned. The implementation plan is divided into two parts. The first part talks about the approval of the resolution plan, whereas the second part talks about the implementation of the plan. It is deemed that the COC had approved the resolution plan on 20th July 2024, and a letter of intent was issued to the corporate debtor. It was unconditionally accepted by the corporate debtor on 26th July 2024. After which an application was made to NCLT for the approval of the resolution plan on 28th July 2024. It is also deemed that the NCLT has approved of the resolution plan on 5th August 2024. Thereafter, notice will be provided on the corporate debtors website and an intimation to all the creditors will be made. Part 2, implementation. A monitoring committee must be appointed under the sole guidance of the instruction of the monitoring committee. The appointment of the monitoring agency under the sole guidance and instruction of the monitoring committee. An infusion of upfront amount would be paid till 25th August 2024, where the distribution of CIRP costs would be paid in priority. There will be a nomination of the new directors of the board of directors of the corporate debtor who are qualified to act as directors of the corporate debtor in terms of the code and the applicable laws. And the board and the board of directors of corporate debtor would be to play this new board. The distribution of the deferred amount amongst the creditors in accordance with the plan will be within 60 days. Therefore, all the amounts are supposed to be paid to the financial creditors as well as the operational creditors within a period of 60 days. Chapter 6 details the reasons for failure and feasibility and viability of the resolution plan. The resolution plan will be approved by the Committee of Creditors under Section 30, subsection 4 by a majority of 100%. With regards to the commercial wisdom of the CBC. May I seek the permission of the bench to mention the reasons for failure and feasibility and viability? The resolution plan is in compliance with all relevant applicable laws and does not contravene any of the provisions of the time being in force, and it also conforms to all requirements as specified by. Thank you.
I have questions.
We are not mentioning any reliefs and waivers with regard to the instructions of the competition, but we would like a relief with respect to the government telephone service provider. We're paying them 50,000 instead of the admitted claim of 10 lakh rupees. Therefore, we would request for a relief of the remaining 9 lakh 50,000.
Allows for against asset the past.
If the claim is not admitted in the resolution plan, the resolution plan is passed, all of the claims that were all of the money that was claimed by any of these stakeholders that would stand extinct.
And the other question see how can we supposed to be?
So we will propose an agreement that shall be entered into to record the aim of the Japanese stakeholders and make into an agreement that would bind them to not make decisions that would adversely affect the value maximization of the company, and to notify the Indian resolution professional if the latter is compelled to take any such decision. The Japanese authority has to be mindful of the course of the Indian proceedings before taking any decisions in the Japanese proceedings. It's page number 8, the treatment that will be provided to the international operation creditor. The asset in Japan would also be preserved on a best efforts basis, and if the asset is sold, the proceeds be moved to and would be deposited in a bankruptcy account. And the distribution should be conducted in consultation with the Indian resolution professional and its authority. The official right to attend proceedings in the two jurisdictions without being legally bound by the laws of any group. Thank you. According to the competition, there cannot be any infusion or fresh funds. Therefore, it would make each shareholder and an NPV account. Thanks.
Into votes.
Not the IBC per se, but elsewhere, government and senior activities.
That is
Not for IBC or otherwhere.
so we are
All lawsuits.
yes.
Each year.
Second year. So we both are from second year and Sarisha is from a third year.
Yes.
Yes. I'm from GSW. Sarisha was from Faculty of Law Delhi and she's from IP Delhi. So basically, yes, sir. So probably
We are from GLC Mumbai, Pineapple.
Yes.
What do you?
All, but this is the 12 plus 5 or
3 years.
You all don't do, you all have morning class.
Yes.
Yes. What do you do with your friends?
I'm chartered accountant. Yeah. I'm working on a strategy meetings. I am working with DSP legal currently. I am interning there. I've got a replacement of. And you're not doing.
Yes.
Correct. That's a big touch of yeah, it's so so it is a very tough signing the whole it's done and the side get the first there's some of the better on this it's for myself not seeing the performance of this law for example not being paid of the double line of opposition. But you know, it's a little bit advocacy is not about it is also it's a question of that is the case. Knowledge of we can put its own to just avoid it or show it. Right. Because don't really know the sections. You don't take it. Some people will immediately say less than a second. So this is the second question bench. Focus on but advocacy is confidence, clarity, thinking on your feet. Try not to this and bring what suddenly take that back like this. All this together is so confidence. Because if I have the advantage of being professional, being market. So was long playing. But that's what we talk. But the fact that how are again but they're dealing with this the final itself is correct. So for me, as far as that system is that you will compete in their comments. Obviously, you will compete because of these that you're senior. So that's what you that is the thing that it was. We were a second and that's what the criteria was. Of course, not. But what it is that how do you teach us peace? It's that the second is that your digital matters. Although you should still that's why I asked before. As nice. Very everything is enough after finishing. That was it that I third bench. And that's not still you can't look at the other member in this one. I won't point out this. That was very responding clearly, not responding I don't think. Right. Simple. Yes, that just give the guys testing how confident you are, how and how sure you are about it. So that just like a dictionary even 30 seconds
Then, where the answer or then I want to please that trying to sort of understand. So these are the things. Not that we judge you with that, but of course there is similarly answer the questions. We answer the questions will not answer it. But it's some of it, at least we can answer. In some, but some of it just sort of didn't make it. That one. And the last, a little bit question, which is the management of line. So check this. There was a sign, but that approved by the heavens. We have to say that not everybody has sold, but for everybody. Because if I get together and say, oh, we have a protocol, so we can. This always says, what's for something? That Canada's protocol says that the next order so then this product and everyone can send me so and therefore I was asking what happens to the city that the city not notice because that is not true number and property will be attached. It will remain attached. Not accept that it will be a lot of business. And what's that said that we are saying. So now there are certain said to become and the protocol because that protocol is actually a very model. And we know that how it is even because I was one who actually happened that but it is not as but just because that even one thing that happened. Yeah, the news of games were not filed in games were filed before that or how could they because they games are filed but I had to that we made the same right everything. That's how the United Kingdom will not fight. So what's the information that is understanding? What the way this is by one touch. This said, from all that you should be but last everything whatever don't companies video and for it is what is so that this must be so that's the and that's why I say accurate tracking the process with the heart bench is all this right. And that will just be and yeah, because I think that I have lost a lot of patience and knowledge. I'm national, but what we discuss ultimately is get out of kids some knowledge, efficiency, dignity, and how you got it. Sweat, bench, what that is. All that. Exchange get the yes.
Right. Just had to say it was fantastic. This is not just law. Insolvency involves 20 laws. And the facts that you were given, you could have spoken on FEMA, you could have spoken on 10,000 things. Okay, what is impressive is your ability to comprehend process. Most of the times, cases get delayed in the honorable courts because lawyer or representative goes wrong on process, timelines, and sometimes the bench is fine. If it happens by talking, the bench is not fine. So, what you've done in this short, and I think you are much younger in the sense, or in the fight, right? Both of you, yeah, so the age difference is visible, but that doesn't mean that the intellectual difference is visible. What it means is that they are a bit more mature in age, that's it. But as far as the competition goes, as said that they are already senior. So I have the right to call them sir and ma'am. What I want to say is that fantastic solutions, so amazing, yeah, reading of the law would have required a little bit more understanding depth. I think it shows that the preparation time may not have been adequate, but that's fine. I think, and if these are the two things we are seeing over here, I'm sure it's been a good competition and you appreciated the facts very well. And it's the journey, it's an amazing journey. Just enjoy the ride, very positive. There are a lot of failures, but there are amazing amount of success. But don't give up. So just continue this journey. You started it, got an additional degree, fantastic. Degrees won't take you far. It's what you learn in the journey. So the more you expose yourself to these competitions and put, this, maybe you're a litigate lawyer, you're visible in the courts and the tribunal. And I'm sure you read about the great jurists, all of them started, whoever started in Bombay went to the tax tribunals, just practice, practice, and practice. Nothing else. Thank you.
And the medal, of course, win the prize. So the number open edition. So,
Thank you.
Thank you.
all of you are requested to join us for the validity session in hall in the admin block. Again, and executive session.